The court found this Phoenix homicide detective lied, repeatedly mishandled evidence, and then she received a confidential disability retirement and claimed to be too unwell to even testify. We broke all those stories. This scandal, though, just caused a judge to throw out a conviction, and it's likely to lead to appeals in dozens of other cases.
That takes us to our story tonight. Prosecutors are still fighting to keep that detective's past a secret, even against the wishes of the court. Here's ABC15 Chief Investigator Dave Biscopine.
The Maricopa County Attorney's Office declined to comment for this story or answer questions. But there's a lot happening right now, so we'll go through it all step by step. And it comes down to a pretty basic question. When can police and prosecutors keep a detective's history of misconduct a secret?
And also, I did review.
This judge recently overturned a conviction in a murder case. And it's because of what police and prosecutors knew about Detective Jennifer DiPonzio, but hid from the other side.
But as far as the defense knew, Detective DiPonzio was a detective with an unblemished record who, for personal reasons, was not available to testify at trial. That's the entirety of their knowledge. That doesn't come close to scratching the surface of what the reality was.
So what was the reality? Well, we've reported on it for more than a year.
Tonight, a major new chapter in an ongoing ABC15 investigation. By now, you've probably seen at least one of our reports about this Phoenix homicide detective.
Her name is Jennifer DiPonzio. She has a history of mishandling evidence that's currently impacting 37 court cases and 61 police investigations. But DiPonzio has not had to testify in court or answer for those mistakes. After she was confronted with the problems, she went on medical leave, then retired under a confidential disability claim.
Because the defense didn't have access to all the information that would have made her a critical witness. And you can't continue to just ignore that point. You can't. That's just simply patently unfair.
At the hearing, this judge essentially scolded the prosecution for keeping all of that a secret. He then issued a ruling calling DiPonzio a liar and tossed the conviction against Randall Barnes.
It's unusual to have a case overturned. It's unusual to have a case overturned where the person pled. And it's unusual to have such strong language.
Seth Apfel was one of the defense attorneys in that case.
If they play these games, there's going to be accountability.
Now, Randall Barnes is 30 years old. He's accused of shooting another man, and officials charged him with first-degree murder. He claimed self-defense, but pleaded guilty to manslaughter. His lawyer says the reason is simple. The risk of going to trial was too great.
Because if they hadn't, they could have been facing a life sentence. So I think everybody's different as far as what they would do when looking down the barrel of a life sentence.
Both parties came here and said, yeah, we're ready to
In court, MCAO argues that since Randall Barnes accepted a plea, it means his conviction is a done deal. No do-overs.
Didn't know why or the level of misconduct that was happening in the background.
Right, but nevertheless, we're still prepared to present their defense without...
But they didn't know this whole other defense existed.
But again, you're not entitled to a perfect defense.
The judge didn't buy that argument. In his order, he wrote, in addition to all of DiPonzio's issues in other cases, she also lied in the Barnes case and misled the grand jury to charge him in the first place. Quote, DiPonzio misled the grand jury when she testified that the defendant was identified as a shooter by a witness. And DiPonzio in this matter engaged in misconduct and lied about it in an interview with defense counsel in this case.
I guess in your...
We got audio of that lie during the pretrial interview.
Have you ever been disciplined? And I ask this of everybody. Coachings, write-ups, let's just sit down and talk, suspensions, anything like that?
No suspensions. 2007, failure to obey a direct order.
Okay, and do you remember what that was? That from like a court appearance or from a supervisor?
That was from a supervisor for a vacation to Hawaii and not reporting to work during Super Bowl weekend because I was on a Hawaiian cruise.
Okay. Anything else that you can remember?
No.
Okay.
And that was clearly untrue at that time. She had multiple disciplinary infractions.
Records show At the time, DiPonzio had at least a handful of disciplinary actions, including failure to complete reports and follow up on cases. At the hearing, the judge also asked if DiPonzio is on the Brady list.
Yes, she is on the integrity list.
And that raised a bigger question for the judge. Why isn't MCAO notifying defendants in all of her past cases about her repeated problems? To the judge, that would be the just and ethical thing to do.
Shouldn't the county attorney's office be notifying defendants then?
I don't know what they do or do not do, Your Honor. I'm sorry, I can't answer that question.
Right.
That's why the judge wrote this footnote in his ruling that dismissed the Barnes conviction. Quote, according to counsel, there has been no disclosure by MCAO to defendants convicted in cases involving DiPonzio. The court is concerned and asks that MCAO comply with its disclosure obligations as soon as practical.
It's been more than a year and a half since all of the evidence of her misconduct came out, due to the efforts of yourself and also the efforts of several other attorneys. MCAO needs to start informing defendants who are impacted by DiPonzio's actions and then let the court process play out. Some people will remain convicted. Other people may have grounds for relief. Some people may be actually innocent. It's up to the court system and the process to flush that out.
So what's happening now? Well, a couple things. That defense attorney, along with the ACLU and a coalition of defense attorneys, sent MCAO a letter. It asks if they can help prosecutors go through past cases and help notify defendants. And what did MCAO say in return? Well, they said no. In a return letter, they are appealing the Barnes ruling and essentially wrote that they're not going to do what the court is asking because they're confident that the appropriate disclosure has been made. I'm investigator Dave Biscobing, ABC15, Arizona.
Several defense attorneys tell Dave there could be a snowball effect here. At least one other appeal has already been filed, and there could be dozens more coming. You know, Dave will stay on top of this case and the fallout. You can catch up on all of his award-winning reporting at abc15.com/investigator.